I don't know if anybody out there is old enough to remember one of my favorite movies from the 80s, besides The Terminator, but that movie is Jerry Maguire. Maybe it was from the 90s, I'm not sure, but it had Tom Cruise. And in one of the most famous scenes in that movie, Tom Cruise was pleading with his star football player, Cuba Gooding Jr., to please help me help you.
Help me help you.
And it's important for you to help your lawyer help you. But more importantly, it's important for you to help your judge help you. That's what we're going to talk about today. My name's Wendy Hernandez, and as you know, I'm the creator of Command the Courtroom. I'm also a Phoenix family law attorney, and I love creating videos to help you as you go through your child custody case. I know it's overwhelming. I know it's complex, and I like breaking down complicated concepts so you can understand them and so you can go into the courtroom and litigate your child custody case with confidence and with competence. There's tons of videos on the Command the Courtroom channel. Have you checked them out? If you haven't, you better do that now. And also, if you have ever found even just one of the Command the Courtroom videos helpful, please give it a thumbs up. And also, don't forget to subscribe to the Command the Courtroom YouTube channel, because if you hit the subscribe button, you're going to get notified each time a new video drops. And also, hitting that like button and subscribing, then it keeps these videos coming. I love doing them for you. I want to know that they're helping you, and the way you can tell me that is by thumbs up. Let's get into today's topic of the day, which is helping your judge help you in your case. Yes, your child is the most important person in this litigation, or your children are the most important people. But in terms of who is making decisions and directing the way the future is going to go, that's your judge. And what that means is whether you love your judge or you hate your judge, you're going to have to make your judge's life easier, because if you make your judge's life harder, guess what that judge is going to do? The judge is going to make your life harder and possibly your child's life harder too. And nobody wants that. I don't want that. And I don't think most judges want that. So I want to focus in on a couple of ways that you can make your judge's life easier. One of the favorite tools that I use in making my judge's life easier is that pre-trial statement. The pre-trial statement is a memorandum that most people have to give to the judge in whatever jurisdiction they're in prior to a hearing or a trial. And this statement basically outlines for the judge what's happened in the case prior to this hearing, who the parties are, who the children are, what the issues are that are in dispute, what issues are agreed upon, and it also outlines what each party's positions are on each of the disputed issues. Now, that sounded like a mouthful, and it was a mouthful, but if you break down each part, as I just stated it, you may have to slow down this video to write them down or type them out, then you are going a long way, further than most people go, especially if they're representing themselves, in making their judges' lives easier. I have gone through entire trials, and judges have had no clue what a party was asking for because the pretrial statement was not outlined well, and because the person didn't tell the judge, this is what I want, judge. In your pretrial statement, be organized, outline what you want, and tell the judge why the law supports what it is that you want. When I went to school back in the dinosaur age, I actually had to do my legal research by going to a physical place called the library, where there were hundreds, if not thousands, of law books, and I had to figure out how to go to the right law book for the right jurisdiction and select the right case, and then I had to shepherdize physically in order to do research. Thank God times have changed, and thank God that you can find most of this stuff on the internet. It makes life so much easier. And because of this, you can find relevant case law that supports your position. If there is a case that is similar to your case and that is going to support what it is that you want, you should find that case wherever you are, and preferably the case should be from your jurisdiction, and include it in that pretrial statement. Don't make the judge do the research for you. You should do your research for your judge. Now, especially if there's an attorney on the other side, that attorney may support or cite to case law that they think supports their client's case. And in that situation, you're going to need to take a look at the case and try to figure out, do research on whether there's any cases that controvert that case or that distinguish that case. And if you can't find a way to distinguish that case from yours, what my criminal law professor from my first year of law school used to tell us is, you're not thinking creatively enough. So look at the case law that supports your facts, and also look for case law that distinguishes separates your case from the case that the other attorney is citing to. All right, so another way to help break things down for a judge is by submitting some sort of timeline. And I know that there's all kinds of tools online where you can create some sort of visual for your judge about, what happened when, what year certain events happened. It's overwhelming for me as an attorney if I get a big long email from a client that just tells me a whole bunch of things happened and there's no order about when each of these things happened. It is so helpful to me when my client creates a chronology for me, and that chronology can just be an email in writing, but I'm a visual person, and it helps for me to look at some sort of map, a mind map, so I can see, there was like 10 events of domestic violence 10 years ago in this relationship. Perhaps in this situation, there's a significant history of domestic violence, which could impact child custody. We don't know whether your judge receives things better visually or just in writing. And it's not a bad idea to do it in a couple of different forms and put it together as one exhibit and attempt to admit it as one exhibit at your trial. But the more organized that you can be and the more that you can provide a chronology of the relevant events, it's going to make it easier for your judge. So your judge doesn't have to create the chronology for himself or for herself when the decision is being made. Now, on the issue of creating visuals for a chronology of the events that have happened, you can also create legal aids for your court when you're trying to summarize bank statements, for example, or a bunch of police reports or medical records or emails that have come in. A judge is not going to want to thumb through hundreds or thousands of pages of emails or bank statements. So what you can do is make yourself a spreadsheet of the information that's relevant within those records and summarize that information in your spreadsheet. I don't know how to make spreadsheets, but I know people who do. So if you don't know how to use Google Sheets or Excel, find somebody who can help you. There's a lot of people out there who know how to do those things. But if you can create some sort of summary chart for your judge, that's going to go a long way towards making your job or your judge's job easier and making your judge like you a little more. Now, this is my final tip about making your judge's life easier, and that is proposing a reasonable outcomes in your case. And you're going to propose your outcomes in your pretrial statement. Propose outcomes that are in alignment with the law. If you propose outcomes that aren't supported by the law, then a judge is not going to think that you're reasonable. A judge is going to want to understand why he or she should enter this order that you're asking for because it doesn't align with the law in your jurisdiction. So propose reasonable settlements, and really you should be proposing them before you go into the courtroom for a trial. You should be working with the opposing party, if it's possible, to try to settle at least some of the issues in dispute. And I understand there are many people who are dealing with a high conflict ex or a narcissistic ex or an ex who has mental health issues that do not allow that ex to participate in meaningful negotiations. I get that. But it is helpful for you to at least try to enter into those agreements because potentially down the road, after you go to trial, the fact that you reached out with an olive branch could support an argument that you should get awarded at least some of your attorney's fees and costs. So that's what I have to say about making your judge's life easier. And I know we don't always want to do that because we don't always get treated the way that we want to by judges, but it boils down to the fact that your judge, if you go to trial, is going to be the one making the decisions about your case. Do what you can to be the judge's pet. That's going to do it. I will be back with another video soon. Until then, keep on trucking and get out there and command the courtroom. I'll see you next time.